Good afternoon to everybody. I hope you can hear me.
Yes.
Okay, that's great. What we'll be doing today is finishing the module on jurisdiction, and we'll try to see some specific aspects which are related. On the one hand, on the role of the judiciary in a legal system. We have already seen in the in the Anglo-Saxon tradition what the role of judges in shaping the legal system, and at the same time we look also at some very important aspect, which is legal education, which has very much to do. It's what you are experiencing, but it's something that has been going on for centuries, and therefore shapes legal education, shapes the legal system. If you train lawyers in a certain way, well, the legal system will have a certain flavor, and therefore this is also an important aspect. It's not only concerning what you are doing, you are experiencing, but it has a systemic aspect in our course. Now, what we'll do now is, if you remember what we did yesterday, we were just looking at principle of stare decisis, stare decisis, let's say it in this sort of Latin, how we pronounce it here in Italy, and so how it somehow the role that courts have in a common law jurisdiction. Now, what I'll try and do is see how it works in a different model, the Euro-continental European model that generally we call the civil law system. Now, first of all, we should take into account that this perspective is the perspective that we have had over the last 2 centuries, something more like that, from, let's say, from Napoleonic times, from the moment in which codes were the form of organization of the law, whether it was civil law, commercial law, criminal law, or the various procedures. So let's say that since the French Revolution, Napoleonic times, the whole idea is the primacy of written law. Here there are very clear ideological, there's a very clear ideological background, which we've seen when we were discussing on the differences between the French Revolution and the American Revolution, and the consequences that this has had on the legal system. The idea that the parliament expresses the will of the nation, and therefore the law expresses the will of the nation. So the law is an act of parliament. So putting at the center of the legal system parliament, this is typically, as I've said many times, is a typical French position, and it has been mostly accepted generally in continental European countries. So the idea is that in our jurisdiction, which we call civil law jurisdictions, to somehow oppose them or put them in a in a different oppose them to the common law systems. I try to analyze this, but at the end of the course. Well, in our continental European jurisdictions, the idea is that the law is a formal act of parliament. So parliament joins, meets, and votes law, and that is the law of the country. So having said this, and this is the theoretical background, what follows is that in theory, judges are simply those who are pronounce the law. There's this very nice French expression which says la bouche de la loi, the voice of the law. And if you go back to the slides on Cesare Beccaria, you see that Cesare Beccaria was somehow very, and this was before codification in the 18th century, he was not very happy with the idea that the judges could interpret the law as they wanted to interpret it, because according to Beccaria, this would have brought to that for each judge would have interpreted the law in his way, and therefore this would have eliminated certainty of law. So in theory, and this is the theory that develops mostly in the 19th century, the idea is that the judges are simply passive executors of the will of Parliament. Now this is, I'm very simplifying this a lot, but this is more or less the idea that goes ahead and is somehow passed on well in the 19th century and also in the 20th century. In practice, but if we look at things how the law in practice is, we see that gradually decisions, judicial decisions by the courts have shaped, completed, and modified what was the legislative intention. Why? Because whatever we think of Parliament, and we may have the highest opinion we want of Parliament from a constitutional point of view and from an ideological point of view, clearly Parliament cannot foresee anything. Parliament is made of people, of men, and now also women, who establish a rule in a certain moment, and looking at the past. They know what the past is, they don't know what the future is. When the society changes and therefore evolves, or the Parliament must all the time somehow run after changes in society and look at anything that changes, they must change the law, or more probably, and this is what has happened from the 19th century onwards, the courts have adapted the law to the new events, new situations, new needs of society. So in practice, we have seen that even in countries such as France, which has always held until practically 10 years ago that very strong idea that Parliament is at the center of the legal system, and that the judges are, well, they have to somehow follow, that Parliament is the only source of the law, and that judges must somehow implement the law and follow what Parliament has told them. Well, we see that that one has always looked with great attention to decisions of the courts. One has collected them, ordered them, and shown how the law is interpreted by the various courts. So, and what is typical of continental European system, legal systems, is that we find in all continental European legal systems that the law quite intelligently and with somehow an idea that looking forward, uses general expressions which are whose sense is can be adapted to the circumstances. Think of the idea of non-performance of a contract. What is non-performance of a contract? When do we say of non-performance, and when are we talking of partial performance? Now, clearly, this is something you cannot establish. Beforehand. I've ordered 100, and I receive 90. Is that partial performance or non-performance? Clearly, it depends on what we are talking about. were those 100 essential? Just think of a case where you need 100, exactly 100, because those 100 are essential for that kind of business you are conducting. So if you have less, you cannot conduct that business. I'm just making a rather simple example. So the problem of when we have non-performance and when we have complete non-performance, or when we have only partial performance, is something that is left to the courts. Or think of the notion of good faith, which our Italian students are studying this semester. What does good faith mean? Probably good faith at the mid of the 19th century meant something, at the mid of the 20th century meant something else, and now in 2020 means something different. Or fault in extra contractual liability, or public morals. What do we mean? Something that is an act that is against the public morals. Just think of how people, especially women, should go about had to go about in the early 20th century, not the 19th, 20th century, and how people go around now. I mean, what do we mean by public morals? I mean, just think of sexual morals, but also, by the way, people dress, behave, conduct their family life, and so on. So as you see, there are a whole lot of notions that have to be adapted to the circumstances, and generally the law, using these general terms and principles, leaves the courts a very wide discretion in interpreting these principles and applying them to the specific case. So if we want to look at things how they are and not in theory, we have to say that a law exists only if it is interpreted, first of all. Otherwise, it's just something that is written on a piece of paper and doesn't mean anything. And it is applied, it is applied also, it can be applied also by the community, how the community interprets a certain rule and applies that certain rule. So here we have fundamentally, if we want to know what the law is, well, we have to look at the role of the courts in interpreting the law. And we see that throughout these, let's say these last 2 centuries at least, we see various forms of interpretation, which is typically secundum legem. Let's use our nice Latin, according to the law, because the law is very clear, and we use what the English call the golden rule. It's written like that, and we won't it's written like that, and we will interpret it how it's written. In claris non fit interpretatio. So when everything is clear, you don't have to interpret. So that is secundum legem, okay, that's fine. But so often we find interpretation praeter legem. Praeter, that means we just put it aside. We say, yes, the law says this, but it probably the sort of the parliament in that moment hadn't thought that there was something else, and we'll bring this inside the law, or even contra legem. In some cases, we find that the courts have used interpret the law in a sense which is not the sense that it was intended by Parliament, but the courts feel that if you interpret it in that way, it would make no sense. It would be contrary to good sense and to the general principles of the law, and therefore they interpret against the law. And here we see also a very fundamental rule. Sorry, I forgot to put this here. Just let me put this here. the role of analogy, which is another way through which the courts very often supplement what is the empty spaces left by the act of parliament. The parliament couldn't foresee anything, something new happens, and then we have to try to apply the old rules to the new circumstances. And lawyers and obviously the courts use the principle of analogy. So just to show that, I mean, the courts have always, even in the continental European tradition, have played a very important role in shaping the legal system. And here, especially after the Second World War, since we have our modern constitutions in continental Europe, well, there's this idea that the law anyhow should be interpreted in accordance with the constitutional principles. And therefore, and who sets this correct interpretation? Constitutional courts, whether it is the Italian Constitutional Court, the German, the Spanish, or now even the French Constitutional Court, or other countries, obviously also Belgium. Well, this gives us the idea of how you interpret the law in conformity with the Constitution. Because here you have a law that maybe was created in 1804. Let's imagine we are in France and we have the Napoleonic Civil Code, which was enacted in 1804. Now we're in 2020, so that makes 216 years after. Well, there's a constitution, and this constitution in France, well, should we interpret rules set under Napoleon in the same way when we are talking the Fifth French Republic? So just to point out that the principles of constitutional interpretation is a very important aspect of how the system can be evolved and what the role that the constitutional courts have in lawmaking, because they set some principles and then these principles are followed by the courts. So although this is not expressly written, and we do not find this generally in continental European handbooks of constitutional law and of public law, well, we must say that today it is very clear that case law is one of the sources of the law. One, not the most important, not the exclusive, but one of the sources of the law. And here we see, I just put a quote from the European Court of Human Rights, which is there to apply, to enforce the European Convention of Human Rights. We've seen it. So these fundamental rights expressed in post-World War II Europe. And in this case, but we find this principle expressed in many other occasions. In this case, which is a case of 2013, law is, quote, a concept which comprises statute law. Statute law is the one enacted by Parliament, as well as case law. Close citation. So just to point out that we have a general consensus that decisions by the court are law, especially if these principles are come from a high court, typically in France, Cour de Cassation, Belgium, and Italy, Corte di Cassazione, or in Tribunal Supremo in Spain, or Bundesgerichtshof in Germany, when you have a very highest jurisdiction which decides a case and sets a principle, well, that we consider that as law, because judges which are inferior judges, Court of Appeal, first instance judges, must follow those principles if they do not want their decision to be quashed on appeal. So just to point out that when we're looking at the role of the courts, we see that the role of the courts, even though originally they were just considered as silent or very passive executors of the will of Parliament, we see that the role of the courts as lawmakers is very clear also in continental Europe. And so what happens? We see that we have apparently two systems which are opposite, which move from opposite starting points. The common law system that starts from looking at case law and civil law jurisdictions that look at the law as act of Parliament, and they tend to move very slowly together in the sense that gradually in the Anglo-American tradition, we see that the role of Parliament, at any rate of statute law, that is general rules set by Parliament or by government, are increasing also because there is an increasing request for norms, and therefore you have general norms and the courts cannot decide everything. Just think of, let's imagine sort of how telecommunications should work, or the banking system should work, or other aspects of economic activities regulation. So clearly there's an increasing amount of norms in regulatory matters, and this is in the Anglo-American systems. At the same time, in legislative systems, traditionally continental European, there's an increasing role of jurisprudence, that is the role of the courts in establishing what exactly the law meant, or how it should be applied. So you see that this convergence in the system, one system that starts from case law, the other system that starts from acts of Parliament, and then they gradually move and are on the many aspects quite similar if we look at certain very broad lines and directions in which the legal system is going. So just to point out that the courts play, and this is why we're so attentive to jurisdiction, we always look at court decisions because we feel that they are one of the sources of law. And as I've tried to sum it up here, sorry, let's see if I manage to, yes, here it is. So if I can just do a very general conclusion, it is a very simplified conclusion, but just to try to set some firm points, that the legal system is composed of many building blocks. Just imagine that there is a building, there's a building, and you need lots of materials to build, to create. You need stone, you need bricks, you need wood, and you need metal, and a whole lot of elements to create a legal system. And so surely we have legislation and normative texts, which are one of the blocks of a legal system. We have case law wherever we are, whether we are in common law jurisdiction or in a civil law jurisdiction. Then we have social practice. Now this is very much studied in the US, this idea of social norms, and the idea that on the whole society does not need all that number of norms. If you look at one of the main tasks that anthropologists have when they study so-called primitive societies, is understanding how they organize. These societies are organized, and they have no written rule. Just think of populations who are in the Amazonia or in the forest in tropical Africa. Do they have parliaments? Do they have sort of someone who comes and goes on television and gives tells what the rules will be for the next day. No, they have social norms, so that society, the community, adapts itself to certain rules and follows certain rules. So social norms are very important. The best example that we generally like to use is there's nowhere in Great Britain there's the rule that when there's a bus, you queue for the bus. But when you are in England and you want to get a bus, you queue, you make a queue. There's no act of parliament that says that you must queue for a bus. And if you don't queue for a bus, well, you will be frowned upon by the people who are queuing for the bus. While in other parts of the world, very civilized world, people don't queue up for the bus. They just sort of wait there and then they climb on the bus because they feel there's no need of making a queue to climb on the bus. So just to point out that social norms are a source of law, because when the community agrees on certain behaviors, well, those behaviors, and if you do not comply with that behavior, then there will be some negative consequences. These negative consequences can simply be reputational consequences, sort of isolation. You're isolated because you do not comply with a social norm. Well, this is a part of the law. And then finally, as another source of the law, we have legal doctrine. In as much as the role that legal scholars, typically university professors, somehow play in directing the interpretation of the law. This is very important in certain jurisdictions. In Germany in particular, there's this long tradition which goes way back to the Middle Ages, but it was particularly strong starting from the 19th century, the role of legal doctrine in steering the sense of the law. If you wanted to understand what was the meaning of the law, you went to look at these very big volumes, these books by these great German professors who devoted their whole life writing tens of books on non-performance of contract. And when you wanted to know what one meant by non-performance, well, you went to look, the first thing you looked at was legal doctrine. So just to show that also this is a source of the law in the sense that it somehow indicates the way in the way norms should be interpreted. So just to give you the idea that the legal system, we should tend to see a legal system as made of many faces and many construction materials. And all these construction materials go together and you must blend them together. You cannot sort of put them sort of on one side, you put only the legislative acts of parliament, on the other only case law, and then there's another side, you put social norms and the books of the professors on the other side. No, they all blend together and somehow you mix them together, and this gives the building of the legal system. And sometimes it can come in a certain way or in another way, depending on how much you put of one element or of a different element, if I can use this metaphor. Now, this analysis of the sort of the role of the courts as lawmakers brings us to one of those issues that we analyzed at the beginning. If you remember, at the beginning, we were analyzing the role separation of powers. So this great idea by Montesquieu of separation of powers, legislative power, executive power, judiciary, keeping them separate, mostly the judiciary, which is there to somehow balance the conflicts between legislative and executive, and also to protect citizens against abuses of the executive power. So this idea that separation of powers is still with us in our contemporary societies, 270, 260 years after it is still there, and we still have this idea. But when we start giving to the courts this very strong power. We say that the courts are lawmakers. Well, what are the consequences in this balance of powers? Because we are interested in this, because clearly it has a constitutional significance, in the sense that obviously when we look at the Constitution, we want to know if each power remains in what its constitutional prerogatives are. Because if government, if the executive does what the legislation do, or the parliament does what government does, typically if parliament starts doing laws which are tailored only for one or very few situations, instead of doing general norms that should concern for the future an unlimited number of people and cases. So we are interested in understanding to what extent, when we establish the courts have a very important role in lawmaking, well, if they're lawmakers, what is the relationship between the legislative power and the judiciary power? Isn't there an invasion of the judiciary power of the legislative prerogatives? So just to point out, this is not a theoretical issue, this is a very practical issue that we find in many jurisdictions. So here we have two models, and it's interesting seeing that these two models come both from, we can use, we can analyze these two opposite models, looking at two experiences that come both from the Anglo-American world. In England, we have this very long tradition of so-called judicial self-restraint. And on the other side of the Atlantic, we find in the US the idea of judicial activism. Now, and these are principles that are very clear, they've been amply studied. And what does judicial self-restraint mean? It means that we will find throughout these, let's say at least 2 centuries, we will find a whole lot of decisions, especially by the highest British court, the House of Lords, Judicial Committee of the House of Lords, until 2007, and then later on the UK Supreme Court, in which the English judges say, well, we will not enter this field because this is the field where Parliament must decide. It is not up to us to decide, and we will exercise our self-restraint. So we will stay back and leave this problem to be solved by Parliament. Now, this is, if you want, on one side, typically British, being sort of politeness of one institution, judiciary towards Parliament, but it is also a very clear political move. When the English courts, typically House of Lords, and then UK Supreme Court, says we will exercise judicial self-restraint, it is saying, I will not enter into the field of Parliament, but at the same time, telling to Parliament, don't enter in my field. So it is somehow setting a boundary, saying, here's the boundary, I will respect this boundary because this is your field. This, you can decide in this field, and you have the power to decide in this field. I will not take a decision which somehow will impinge on your powers, on your prerogatives. But please remember that I, judiciary, have certain prerogatives, and these prerogatives are dating back from centuries. You, Parliament, will not invade my prerogatives. So behind this idea of judicial self-restraint is not only the idea that sort of Parliament, that the judiciary somehow moves back and says, "Oh no, I don't want to sort of tackle this matter. And we find various cases in which continuously the House of Lords has had, English judges have said, no, I will not enter, I will not decide that case because it is up to Parliament to decide it. But it is also a way of reaffirming its jurisdiction, its jurisdictional powers, and what it can do and what Parliament may not do. So just to point out that this is very important. Now we don't have, or what government may not do. So just to point out that this judicial self-restraint is one position in which the courts tend to sort of not to follow too much social instances and how society changes. If society changes, it is up to Parliament to change the law. The English judge will follow its tradition, and only if the Parliament changes the law, then, well, in a certain way, well, British courts will follow. To the opposite, we find this very strong idea of judicial activism in the US. And this is something which is, again, extremely studied by lawyers and obviously by political scientists and by sociologists, of the fact that the courts in the US, mostly federal courts, but not only federal courts in certain states, just think of, let's take New York or California states in certain matters, family matters or financial matters, sort of being so. But generally, let's look at federal courts. Well, the idea that the courts have the role of they should somehow follow, adapt their case law, jurisprudence to the changing times. And therefore there is some social pressure on the courts to change. And therefore the principles that were affirmed in a certain moment, even if they were good in that moment, and they can no longer be applied in a subsequent moment. And therefore, according to the changes in the economy, in social behavior, in demography, in a whole lot of aspects, well, then the courts have to somehow change law. And here we see that the idea is that the courts anticipate decisions by Congress and by the executive. Typical example, same-sex marriage, where even before legislature, marriage in the US is a matter of state competence. So there are 50 states, and they can decide, each of them can decide how they want. Before there was a groundbreaking decision by the US Supreme Court, but it is family matters are competence of the states. Well, the courts went ahead and saying, well, we should recognize same-sex marriage. So just to point out that it is this is a very recognized role of judicial activism. Now, obviously, you can analyze this in one direction, another direction. Clearly, in the US, you will find that according to the political tendency of the commentators, well, often judicial activism is seen very favorable if it goes in the direction of the political ideas of the observer, while obviously it is not seen as acceptable if it goes against. So there's quite a lot of political discourse behind this judicial activism, but this has very much to do with the American society, with the notion of we the people. So the courts feel that they are democratic courts. Remember that in case of state courts, in many cases, the judges have been elected,
And therefore, although they, once they're elected, they cannot be removed, they will remain there for the rest of their life, but they feel that they have somehow have had a democratic mandate, and so they will not keep the law as it is. They will tend to adapt the law to the change in society, change in circumstance. So just this is something that has to be considered, because again, when we're looking at the role, when we're looking at jurisdiction, we want to understand what is the role of jurisdiction in certain systems. Well, we have to see if the tendency of the courts is that of political neutrality, saying, no, this is a political issue, and it is not up to me to decide, it will be parliament or government that will decide it, or instead a choice for judicial activism. And this gives, obviously, this changes the legal system, because certain legal systems are very sort of mobile because of the activism of the judges, while of the courts, while in other systems are more they are conservative, they move less and leave the sort of main decision, the turning points, they leave it to Parliament. Just to show you that this is a very important issue. It has to do with political science. It has to do, obviously, with sociology of the judiciary. But we are interested in, as lawyers, we must understand we can't just blindly go around blindfolded and ignore that the legal systems move also according to certain tendencies that we find in that system, where are rather conservative in the sense that you stay still, the courts would stay still and wait till Parliament moves, or active courts where the courts precede the role of Parliament. Now, just to look at this, show that this is something that has very much to do, and we see that jurisdiction, why jurisdiction is so important from a constitutional point of view. Well, that there is this growing push that we find in all Western societies, this social and political request for judicial review. The idea that decisions, public and private decisions, should be reviewed by the courts. Accountability, this is a term which is commonly used. It's used not only for those who sit in political instances, government or public officials, but it moves also to somehow to private entities, typically corporations. Just think of, we start saying accountability of Google, accountability of Facebook. So we have private companies, almost big companies, and we say they should be accountable to society. Who's going to decide? Well, the courts decide if they are accountable. They should respond. They should follow certain social needs. They should work also not only for the profit of the shareholders, but also for in the interest of the of society. So just to point out that this notion of accountability is expanded, and therefore this brings again more greater role of the judiciary. So the judiciary becomes, in last instance, the decision maker, and therefore we have a shift of power from the legislative power and the executive power towards the judiciary. So just to show you that when we say, oh, there should be judicial review, well, we are somehow saying that the judiciary should have more power in the various in separation of powers. And here also we should look at this further aspect, because we are talking of courts, but we should consider that the courts, well, we tend to look, what we look at civil courts, commercial courts, and criminal courts. And we look at sort of, these are the main courts we look at. But we should consider that they are In the continental Europe, we find typically certain specialized courts, like administrative courts and the Court of Auditors, which have a constant control over government and public officials. Think of sort of public expenses, how public expenses have been made, and therefore the Court of Auditors, which we find in most continental European countries, have a very strong influence on how government is acting. And even in jurisdictions where there are no specialized administrative courts, we've seen that in the traditional, in the continental European systems, cases in which the administration is a defendant, where there's a private party that challenges the exercise of power of administration, they go in front of a specialized court, which is administrative court, while in the Anglo-American model, they go in front of an ordinary court, although the judge may be specialized in that specific field, but generally it is an ordinary court. But even in those jurisdictions, such as Anglo-American courts, where systems where administrative control over the administration is in front of ordinary courts, we see that there's a constant control over government. And so this is what we generally call regulation by adjudication. So the adjudication is the role that the courts play in deciding cases, and they somehow regulate economy. So somehow, if the powers that the courts exercise in analyzing the exercise of their regulatory powers by government and government agencies and independent agencies, well, this means that the courts are deciding instead of government and its various forms. So just to point out, this again is a shift of power, and we see that progressively there's this dilution of this notion that we generally call as judicial deference. Judicial deference is when it's something like similar to judicial self-restraint. Deference is saying, well, this is a very technical matter. Just think of the issue of sort of regulation of transport. How many trains would circulate on a certain railway, or sort of how antennas of a 5G network should be deployed. Now, this is a technical issue. So generally, traditionally, the courts have said, well, we have deference towards these technical matters. We are lawyers, we are jurists, we are not technicians, we do not know anything about these matters, and so we assume that the government and governmental agencies have acted properly. So this deference towards towards technical decisions by government. And here we see that increasingly the courts stand in and say, well, but you should have done this, you should have done something else. So just to point out that there's increasingly the role of the courts in entering into very technical, just think of financial, technological or medical aspects, and deciding what should be done or should have been done, or environmental issues which are very complex regulations that concern pollution and so on. Just to point out that this is another aspect of the role when you ask for judicial scrutiny over and review over certain acts of administration, and you empower certain courts, well, this is what is the consequence. And so finally, and this is the last point I want to make in this first part of the lesson, that if we have a political science approach, so we look at it not as lawyers, but as someone looks at someone I'm Italian and I go to the US and I'm a political scientist and I don't vote. I have no interest. I'm not an American citizen. I don't vote there, and I'm trying to observe what happens in the US. Or a political scientist comes from the US to Italy, France, Great Britain, or Belgium, and tries to analyze and tries to understand what's going on. If we have this kind of approach, we see that the three powers, these three powers that are still there, as I've mentioned, they're all there. We have this idea: legislative power, executive power, judiciary, are always in stable equilibrium. They never are they stay in their boundaries, which are set now by the Constitution. So the Constitution sets certain boundaries in which what is the role of the legislative power, what is the role of the executive, what is the role of the judiciary. Well, it has written this 70 years ago. Let's imagine we're talking about post-war, World War II Constitution, but this is very unstable. And each power, historically, we look at this now, we have 70 years, that's quite a big time span. Each power tends to invade the space of other powers when these are weak. So if Parliament loses its power, government will step in. If the power of, we could do this look at this very commonly in many countries. When government is weak, it may be Parliament or the President of the Republic, who is not part of government, not in a semi-presidential system, but President of the Republic, who steps in and plays a certain role. Or when Parliament and government are undecided and are very slow in taking decisions, well, the judiciary will step in and take decisions for them. So point is, what is the influence of political theories? And political theories have a very important role in shaping these decisions. Who ultimately should be the decision maker? And especially if you put stress to the idea of rule of law, and we've seen that rule of law is a term that is born in Anglo-American tradition, this idea that the rule of law means judicial scrutiny in the US and England, continental Europe. No, that is not, our term, as we've seen, État de droit, Strasse in German, is not the same as rule of law. Well, the Anglo-American idea of rule of law means that, there's rule of law when there's judicial control. So if this idea of the theory of rule of law becomes dominant, and it is dominant also in the European Union, well, this means we are increasing control of the judiciary. And so you're telling the judiciary, well, you should control what the executive and what the parliaments are doing. Now, this is just to say, obviously, you can see it in very different ways in democracy, and this is the nice part of democracy, having been able to see things in a different way. But just to have very clear as lawyers that the role of jurisdiction is not sort of a neutral role, something that is set for all times and it's always there. No, it changes according to the systems, to the times, to the circumstances. And, well, for example, in these times of emergency, we see the role of government is predominant. Parliament is substantially set aside. Judiciary cannot intervene, or has intervened, but very slightly. And it's the executive power that is leading in cases of emergency, which generally happens in most emergencies, because it can decide, or it should be able to decide in very short time. So just to point out, we have, as lawyers, we are interested in understanding how a legal system works and to compare these various legal systems, because we always may have lessons to learn from different legal systems than from our own. having said this, and I'll stop here at this first part, I just wanted to, let's see if I can, now let's see, sorry, why don't I have, I should have, sorry, I'm looking for my, I apologize, I sometimes lose the chat. I don't find the chat, it should be somewhere. Are there any questions on this first part? Yeah, here we have chat. Okay. Yes, thanks. So first question is by Adimani. What do you think about the Clax's complaints and judicial power competence about what happened in Italy? Well, this is a very political issue, so I don't think, I mean, whatever my view is, one of view of Italy, we have 60 more million inhabitants, and so my opinion is quite immaterial. I just like to point out that one has to, as lawyers, obviously as citizens, we are entitled to have the most different opinions. As lawyers, we must understand, obviously, what is our position. Are we theoretical lawyers? Are we professors of constitutional law, and therefore we must analyze so the constitutional balance of powers in a certain period? We are legal historians. Well, we will analyze it in a certain way. If we are instead in as practicing lawyers, well, maybe we will start discussing whether, for example, in these cases, just let's take in these times, troubled times, the issue of restrictions to movement, personal movement, and to economic activity. Well, has the executive gone beyond what are the powers that the Constitution gives to it? So, and should we go to the courts and have the courts strike that down? But we can also see the opposite. We see, as Italian students know quite well, there has been a very serious situation in southern Italian town, Taranto, where one of the main European steel factories is, and dramatic problem is the health of the community against the fact that the economic needs of that community, whose main economic source is that steel factory. And with the judiciary that stepped in, saying, and closing the factory, and deciding that the factory could not go on if it did not comply with certain rules set by the judiciary. And this was challenged by various authorities, local authorities, and obviously by the company itself. And at the end of the day, the Constitutional Court said, no, sorry very much. It is not up to the judiciary to decide what are the environmental constraints of an economic activity. It is up to the national and regional authorities to decide what those standards are. So just to point out that this is, you have to, first of all, you have to distinguish. You have to look at case by case, and then one good thing of being a lawyer is that you can take sides. You can take sides. You can be, well, judges should not take sides. They should be third party. But if you are a practicing lawyer, you can be on one side or on the other side, and you must find good arguments for the side which you are somehow assisting. So just to point out that you can find, to bring it in a much broader perspective, that obviously if you have, from a historical perspective, you can read it in a certain way or read it in a different way, but this is part of thanks God, of freedom of expression and freedom of thought, and how you can interpret the historical facts. Now, Panagia is, does the accountability by the court have to do with right to appeal? No, 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 no. Accountability means the fact that if you take a decision, you have to be accountable. So typically what it has to do with, if you remember that idea, the king can do no wrong. And so the king is not accountable. Now, so if the king does something utterly crazy, well, he cannot, only God can judge him. And the only judge of the king is God. No court can decide. Now, this idea that has went on well into the 19th century. Well, this idea has been progressively superseded. And the idea that anybody who holds some post of responsibility, some function of responsibility, must be accountable for what that person or that institution does. So this is the notion of accountability. And therefore, the fact that you are accountable means, and how are you accountable? Typically, in many cases, this accountability was only political. You were a bad politician. Well, you are accountable in front of the, when people go to vote, if they think you have been a bad politician, you have exercised badly your prerogatives as a member of parliament, well, you won't be re-elected. So this is traditional idea that there's what you do in parliament is totally not accountable. So the only people who only entity can decide are the voters. Here we see that gradually we've had the idea that even institutions that are not accountable, which traditionally were not held accountable from a legal point of view, from a political point of view, yes, but from a legal point of view, not, gradually are becoming accountable. Here we see, and it's very interesting that we can't analyze it here in our course, we have a whole series of decisions by the European Court of Justice, now Court of Justice of the European Union, which has held progressively liability of bodies which were not held liable. For example, Parliament. Can a citizen bring a case against Parliament? Well, typically one said, no, you cannot bring a case against Parliament. Parliament is high up, and so the citizens are down. They can't. Parliament has immunity, cannot be challenged. The European Court of Justice has said, well, we can't bring a case against Parliament, but you can bring a case against the state, because the state comprises all its institutions, including Parliament, if, for example, Parliament has not correctly transposed a piece of European Union legislation. Let's imagine that Parliament, the Spanish Parliament, happened with all parliaments of the European Union. So it's something that we find from Romania to Portugal and from Cyprus to Finland. So it happens that they have not correctly, Parliament has not correctly transposed, and therefore someone feels damaged by the incorrect transposal of EU directive of that is a law by the European Union. And so the citizen that feels damaged by this can take a case not against Parliament but against the state, and therefore ask for damages against the state. So this has to do with accountability. It shows that here we have areas in which the Court of Justice has established that there is liability of the state for the wrongful act, the incorrect act of Parliament. Here we have, I'll just give you the names of the cases, because you'll meet these cases. They're very important cases. In this case, which is called Franco, this is a case that comes from Italy, and the case was a case of protection, social protection for workers of a company that went in liquidation. And Mr. Frankovich should have received payment for all the time he had been working there, but Italy had not correctly transposed EU directive, and therefore he received no protection. He should have received something like 100,000 euros for the final, for having ceased his job as working in a certain company, but the Italian Parliament had not correctly transposed, or had transposed very late, that directive. And so the case went in front of the European Court of Justice, and the European Court of Justice said, well, the Italian state is liable for not having transposed that directive. Or we find generally many systems idea that the judges are completely irresponsible. They have no responsibility. Again, the Court of Justice, in two cases, one is an Austrian, another one is Italian case. One is Kobler, and the other one is Traghetti del Mediterraneo. In these two cases, the European Court of Justice said, well, if the courts do not apply correctly EU law, European Union law, well, they are liable. I mean, obviously not the judges themselves, but the state is liable for the wrong decision of the courts, which manifestly disregarded EU law. So just to point out that this is, again, shows that the idea of accountability. So Parliament is accountable, or the state is accountable for the acts of Parliament, and the state is accountable for the acts of the courts. So just to point out, this idea of accountability is a growing idea. So I hope I've answered to Panagia's question. Now, Jazevol instead asked, can you repeat the notion of interpretation contra legem and Passini praeter legem? Now, I trust that our Italian students have studied a little bit of Latin, and so they still, and those who have done classical high school, remember it, at least. It isn't so many last year. This time they were probably studying Latin. So contra is against, contrary to the law. So the law says something, let's say, I'll put it in metaphor, says white, and the court decide black. Now, clearly the courts will, how will they do this? Obviously, they will not, if the law says white, they won't simply disregard, but they will say, listen, but this, this law that says white, however, hasn't taken into account that there's a different law that says black, and I think that the law that is leading and that should be applied is the different law which says black. And so I will, notwithstanding what Parliament has said, I will apply that other law which says the opposite of what the Parliament has said. And we find in various cases, we have find decisions of judicial decisions in which the courts, using arguments, various arguments, simply disregard what Parliament has said and go against the decision of Parliament. So that is interpretation contra legem. Instead, interpretation praeter legem, it means simply that you set aside law that said something, and you decide that that case does not fall within that law. And therefore you will apply some different principle, saying, well, that law, praeter, means if you set aside, praeter means aside, you set aside the law and you apply something different principle, and so you disregard. You're going contrary, you're just saying, well, we will not apply in this case because it has not been contemplated. This case has not, this situation has not been contemplated by the law, and therefore I will sort of disregard the law and apply a different law. So this is I hope I've clarified these doubts that you have. Panagias, Gazevoli, and Assini. And if there are no more questions on this first part, then we'll move to, okay. I just, listen, just to point out, you've already studied, our Italian students have studied this in public law, and this is also valid for our Belgian students, and it was until, well, not long ago also for our British students. Please remember that European Union law is not some other legal system of, like the American system. It is part of our national system. EU law is part of the Italian system, as it is part of the Portuguese, of the Belgium, of the Swedish, of the Cypriot, or the Maltese system. So when I talk about, and you will hear about European Union law, well, European Union law is also domestic law. So when I quote Frankovich or Kobler or Traditi Mediterranean, and we find a whole lot of cases, we are talking of principles that are valid in domestic jurisdictions, whether we are German citizens, Spanish citizens, or Hungarian citizens. They are part of our domestic law. So just to make this clear, that every time we talk of European Union law, except for our British students, which Great Britain now taken a different road, but the idea is that European Union law is part of our domestic law. It's not something outside, but we shall see this next week when we are analyzing the international relations of a legal system, a national domestic legal system, and its relations with the rest of the world. Now, as I was mentioning, now what I would like to do is talk of the role of legal education. Now, you may think, well, what are you talking about? Are you talking about yourself, what you're doing now, doing a law in a law faculty and a law school curriculum? Now, clearly, it is obvious that now you are doing a certain experience, but you should consider that this experience you have been doing, this experience has been, you're being preceded by not, for 50 years, 100 years, but for, well, generally nearly 1,000 years, people have been doing exactly or something very similar or sometimes different from what you are doing. Now, this role of legal education is essential in shaping sort of the legal system. I'd just like to remind you that lawyers do not need laboratories, they don't need computers, they don't need sort of enormous sort of infrastructure. They only need, and I will repeat this many times, they only need what they have between their left ear and their right ear. That is their brain. And so the way the brain of a lawyer is shaped, and so it has nothing to do with computers, with books, with libraries, with classrooms. It has to do with what lawyers have in their head, how their brain works. The way you shape the brain of a lawyer, well, this influences a legal system, what we call legal mentality, and I'll come to that in a moment. So this is why we are so interested in, when we're comparing legal systems, we're not only interested in comparing constitutions, the courts, how government is organized and so on. We're also interested in comparing how legal education goes on, because this shapes the mind of lawyers, and it shapes them not only for, in the US, generally you say, there's a class, and you would be the class of, well, 5 years from from 20, should be the class of 2024 or 2025. That should be your class. So it's not only your class, it's all the classes that all those who were before you, myself, and those who were before me, and centuries back. So this shapes the mentality of lawyers. And this mentality, this legal mentality, changes according to countries. It's not the same. And this is why we want to try to compare this. So what I would like to point out is a lawyer, in our view at least, look at it from Italy, and then we look at this different experience elsewhere. So the idea that lawyers are somehow shaped in university. We must always repeat, I like repeating this because this is sometimes forgotten. You know, when you find people come and explain certain things. The first university in the Western world is Bologna University, 1088. And it was created around the law faculty. Bologna University was created around the law faculty. So we've had in Italy a model of the law faculty since for the last nearly 10 centuries. And this model then was replicated because quite clearly it was a successful model, and then went to Padova, and then he went to Siena, and went all around Europe. He went to Heidelberg, he went to Sorbonne, and was copied around the world. So lawyers are shaped, their mind is shaped in university. Clearly, you are, and this is the role of university, is providing you with many stimulus. And so sort of you're all different, and you receive a whole lot of indications, and your brain, which thank God each brain is different from another, receives certain indications, and you elaborate those indications, but you receive a certain imprinting. You know, what is the role of law, what are the general principles, and how you apply those principles, and how you should make those principles, somehow interpret those principles. So the mind of a lawyer is shaped in a law faculty. So what we are interested in understanding is, A, what you learn, because clearly if you are in those who live in Rome, know that in Rome, at least I think 8 or 9, so pontifical faculties, theology faculties, which are faculties which are under the Vatican, Roman Catholic, and which are entirely dependent from the Roman Catholic Church, and where they study theology, but they study also, well, canon law, which is the law of Roman Catholic. So, but they are shaped in a certain way. They will learn canon law, but that is a different context. When we're talking of a law faculty, well, you study many various things, maybe history, philosophy, economics, but you study mostly the law. We are interested in understanding what the curriculum is. So seeing what kind of imprinting do lawyers receive, not occasionally, but throughout a long period, because clearly if the curriculums change every 10 years, well, this is rather this sort of the shaping, how the lawyers are shaped is quite, it's different. But if you see this continuity over the centuries, well, it means that for centuries, lawyers have been educated in a certain way. Let's take, for example, in Italy, just to make an example, 1861 unity of Italy, or we might take Belgium, so 1832. And well, we see how the curriculums, have they changed a lot? Now we see that certain things have been added, and certain topics have been added. How lawyers have been shaped 200 years ago, 150, 150 years ago, how they've been shaped, how they learn. What is the kind of lessons they receive. Now, this is typical. This has always been complained of. The fact that typically in continental European universities, but not only that, there's an enormous amount of lectures. A professor like myself that delivers certain ideas and you must take notes. And there's much less sort of activity to practice writing, solving cases, writing, for example, contracts or briefs, which is somehow common to other legal systems. For example, at the RMFA now we have these legal clinics, but these are for students that are advanced students already in their 4th and 5th year. But just to point out how they learn. Now, this is important how you learn the law, because we should see an experience where you learn the law in a very practical way. And so, and what are the partitions of a legal system? Because the partitions of a legal system, which are set out in the universities, remain in our minds. We enter university in a continental European university, but it's not very different in an American university or British university. And we have certain partitions. We have public law and private law. We have constitutional law, administrative law. We have labor law and we have company law. We have contracts, and then we have family law and criminal law and criminal procedure. So the partitions of the law that we receive when we enter a law faculty, and I repeat, whether you are in the law faculty of Vladivostok or that of Vancouver in British Columbia, or you are in Valparaiso in Chile, or you are in Southampton in England, well, the partitions of the law are not all that different. Then there are some differences, and this makes you, when you move from one country, from one system to another, you ask yourself, where are you going to put, where are you going to find certain problems, certain answers to certain issues. So the partition, the way we partition our law school curriculum is very, very important in shaping the mind. You will, any student in continental Europe will have a certain idea of the legal system and will sort of know, should know more or less what is administrative law and what is commercial law, what is family law and what instead is constitutional law. These partitions should be clear. But this is a way in which we are shaping the legal system, because then we start reconstructing the legal system, and then when I start doing I do 8 modules of this comparative legal systems, I inevitably follow what I learned when I was your age, and how you somehow subdivide a legal system and how you put order in the legal system. Lawyers tend to put order, at least scholars tend to put order in a rather messy situation. Now, having said this, let's see if I can move to my. So, just to see that in continental legal system, historically, law faculties provide not only legal professionals, that is, practicing lawyers and judges, which are typical result of a law faculty, but they also they've always provided personnel for public administration, businesses, and international organizations. So it is a multi-functional approach. Statistics tell us that out of 100, 2020 in Italy, out of 100 graduates from a law faculty, well, only 15–20% will actually go towards the traditional legal professions, practicing lawyer, judge, or notary. The rest will do something different, and they've always done something different. I mean, we find, historically, we find there's a whole lot of people who graduated from law schools throughout Europe then ended up doing something else. I mean, just quote Henri Matisse, the famous French painter. Well, he had a law degree. He even practiced. He spent some time practicing as a young practitioner in a law cabinet and then decided that his vocation was elsewhere. And so, or even Kandinsky, just to point out another painter, just to show that, you know, you can have a degree in law and then follow very different vocations. So this is, but what is the result of this? The result of this is that people who have graduated in a law faculty and have a certain frame of mind, because if you go to a business school, you have a different frame of mind, and if you go to sort of humanities, classical studies, literary studies, well, obviously you have a different mentality. So lawyers which have a certain mentality, which have been brought up with a certain mentality, you find them everywhere. So clearly, when a lawyer, a practicing lawyer, has to speak with a company, well, he prefers, isn't there anybody in this company that is somehow has a legal background, because they speak the same language, they understand each other, they immediately understand what they are talking about, and they can come to a certain conclusion. So this is very important, because it means that the law faculties and legal education shapes not only how the laws are written, because lawyers write the laws, how they're practiced, because then they must be put into practice, and how they interpret it. Now this is very important, because clearly if you take a piece of law and you give it to people who are not lawyers, clearly people will interpret them in a rather sort of different way. So it is somehow complex to explain a legal concept to someone who is not legally trained. So this shows that this has very much to do with the role that law faculties have in shaping the sort of the whole system, and how the law in that system is interpreted and applied. If we look at another experience, which is very much similar, because this is important, you should take into account the fact that I've highlighted lots of differences of the American system in respect of the European system, continental European system. But if we look at American law schools, we see that the idea is more or less quite similar to European law schools, formation of lawyers, but with something that is very different. The fact that in America, most universities are private universities. They're owned by foundations. They're not really profit makers. They're putting all the money they make, they put it again in the system, educational system. But students pay very, very high tuition fees in law, not sort of Yale or Harvard, but let's talk of a medium level law school. Well, until recently, the tuition fees were around $30,000–40,000 per year, compared with zero in Germany or Scotland, and well, 1,000 euros maybe in Italy. So this just to show you the sort of so what happens in the law school, American law school, which lasts 3 years, because before that had college, which is somehow should somehow supplement, but rarely does, what the very extreme weakness of high school, of American high school. But anyhow, in the law school, which is 3 years, only 3 years long, well, if then students have asked for student loans and have had student loans not only for tuition fees, but obviously for housing fees and so on. So they come out of university having $150,000, $200,000 of debts, and they must repay them. And so the whole idea is that the law schools are built around the idea that you become you can immediately practice law. Then if you want to do something else, well, that's your problem. But I'm going to sort of prepare someone who's ready to to enter into the legal profession, and therefore can earn and repay the student loans he or she has received. And as you see, they're important sums. We're talking of, you know, $150,000 to $200,000. Families generally in the U.S. do not put money in supporting their children's education. So it's up to them to find and to repay for their education. So you understand very clearly that the whole system of education is done in a certain way. You are training, the 3 years in which you are training lawyers. Yeah, to use a rather rude expression, they are ready for the market. So students graduate from the law school, they take their bar exam and can practice law, and they will be earning, hopefully they will be earning enough money to repay the student loans they have received. Now, there's in this system, which, and continental Europe and the US on certain aspects are very similar, especially the role of universities in formation. We have a very significant different experience, which is the English experience, which is quite extraordinary for us continental Europeans, but which deserves sort of to be explained in detail, because it gives you also the idea of how, in what aspects English law is different from continental European law. I'm talking of English law, sort of typically English, not sort of Scotland, well, it's something different. English England as geographically England. So we will, but we can't do this today. We'll analyze it next week, and I'll close on this, the jurisdiction model next week, next Monday. Are there any questions? Just let me close. Any questions on this part of legal education on your? Okay, I don't see any questions. Well, I think we can close our lesson. Today's lesson here, and well, we reconvene on next Monday, although I know I won't find a class, because I suppose you will all be going around Rome. At least our Italian students or Roman students will be going around Rome, trying to join up with what this very vague notion of congiunto, which is a nice, for us lawyers, we could do a lot of analysis of what we mean by congiunto. Is it a relative, or does it include also people who are not only relatives? So as you see, there's a lot of, we can analyze these legal issues, and you can think about this from here till next Monday, and I hope that we meet again and you're not attracted too much by other needs, and we meet again next Monday here in this virtual digital classroom.